My Lords, I addressed the fourth ingredient of fair comment before the short adjournment, the obligation to explicitly or implicitly indicate, and the idea that the reader or hearer should be in a position to judge for himself. I was now going to refer to the third element, which is that the comment must be based on facts which are true or protected by privilege, and just make some brief submissions in relation to that, because if that's a zero tolerance for factual inaccuracy, in my submission it can't be right. And then I was going to apply the principles to the facts of the case by reference to the Court of Appeal judgment. So I'm just going back to Cheng now, at paragraph 18, where Lord Nichols says, third, the comment must be based on facts which are true or protected by privilege. See, for example, London Artists and Littler. And my simple point here is that you have to insert an all, A-double-L, between if and the facts, if this principle is to be of universal application, if all the facts on which the comment purports to be founded are not proved to be true or published on a privileged occasion, the defence of fair comment is not available. So if we can turn to London Artists, which is a case obviously post-1952, and that's in the first bundle of authorities at tab 21. Here the allegation was of a conspiracy to close a play. And the allegation was made by the producer of the play, and in fact there was no conspiracy. The case went to the Court of Appeal after the jury had found for the plaintiffs. Court of Appeal's primary finding was that the words or the allegation was not capable of being comment, but there was also reference to the supporting facts. Now, in Cheng, Lord Nichols referred specifically to page 395 of London Artists, which is an extract from the judgment of Lord Justice Edmund Davis. And it's 395C. Secondly, comment must be disentangled from fact, for fair comment is available as a defence only in relation to facts which are either A, true, or B, if untrue, were published on a privileged occasion. Leaving aside privilege, which does not now rise for consideration, if the alleged facts relied on as the basis for comment turn out to be untrue, a plea of fair comment avails the defendant nothing, even though they expressed his honest view. And having stated that as a principle, Lord Justice Edmund Davis continues at 397C. He says it follows that if none, and there's emphasis given to none, if none of the facts so relied on exist, the plea has no foundation and must therefore be withdrawn from the jury.
Sorry, where are you reading?
I'm from 397C, just above the C.
Thank you.
Again, if, as I think is the case, paragraph 20A has to be regarded as setting out a vitally important part of the alleged facts upon which the defendant purported to comment, it is impossible to regard such comment as reasonably capable of being fair. Focus very largely was on that paragraph once its complete falsity was established and indeed conceded. And in that case, at trial, the defendant was forced to abandon his justification defence. So he pleaded justification to the plot and also said that it was a comment because it appeared as an inference that he drew from particular facts, and all those facts fell away. Lord Denning approached it in this way at 391E. the second point, just below E it is, that paragraph starting just below E. The second point is whether the allegation of a plot was a fact which the defendant had to prove, or was it only comment. In order to be fair, the commentator must get his basic facts right. The basic facts are those which go to the pith and substance of the matter. See Cunningham, Howie and Dimbleby. They are the facts on which the comments are based, or from which the inferences are drawn, as distinct from the comments or inferences themselves. The commentator did not set out in his original article all the basic facts, see Kemsley and Foote, but he must get them right and be ready to prove them to be true. He must indeed afterwards in legal proceedings, when asked, give particulars of the basic facts. But he need not give particulars of the comments or the inferences to be drawn from those facts. If in his original article he sets out basic facts which are themselves defamatory of the plaintiff, then he must prove them to be true. And this is the case just as much after Section 6 of the Defamation Act 1952 as it was before. It was so held by the New Zealand Court of Appeal in Truth and Avery, which was accepted by this court in Broadway approvals and Odden Press. It is indeed the whole difference between a plea of fair comment and a plea of justification. In fair comment, he need only prove the basic facts to be true. In justification, he must also prove that the comments and inferences are true also. And just going to the head note, at 376D, held dismissing the appeal that although the comment was on a matter of public interest affecting people at large, the allegation of a plot was of a basic fact, defamatory of the plaintiffs, and not reasonably capable of being considered as a comment, which the defendant had failed to substantiate. Alternatively, in his allegation of a plot, he had made a defamatory imputation without any basis of fact to support it. Similar language in the decisions of the Strasbourg court. Value judgments without any factual basis can be regarded to be excessive. It's clear that both Lord Denning and Lord Justice Edmund Davis found that if the plot allegation had been a comment, there would have been no sufficient factual basis for it. Both judgments contemplate some tolerance for error in the supporting facts. Lord Denning referred to the need to get the basic facts right. If this means a defendant needs to prove sufficient facts to satisfy the honest person test, it is, in my submission, uncontroversial. If, however, it seeks to set a threshold beyond the honest person test, it would be inconsistent with Section 6, wrong in principle and contrary to Article 10, because Section 6 does not discriminate between the type of facts that may be relied on to support a comment. It simply requires that the proved facts are A, alleged or referred to in the words complained of, and B, sufficient to satisfy the honest person test. Defendant simply needs to get enough facts right to satisfy the test, whether they are characterised as basic or not. So tolerance for factual accuracy is also relevant to the fourth ingredient in showing whether the reader can judge the validity of a comment, because clearly the reader cannot be in a position to judge whether a comment is well-founded if it is permissible, as it clearly is, for 19 of the facts to be misstated, but the one remaining fact to be capable of sustaining an unfounded prejudice, exaggerated and honest belief. The reader will not know which facts are true or which facts are false, just as much as he will not know the factual basis for the comment in cases such as Kemsley, where they're not set out in the words complained of. And a similar point can be made where the defendant relies on privileged but untrue facts, because the reader might assume those privileged facts are true, and that will impact on his assessment of the validity of the comment. But if they're untrue, that distorts the process of being in a position to judge.
As to the 19 out of 20,
yes.
Lord Porter, when he was adumbrating that, went on to say the protection of the plaintiff, this is at 358 in tab 19, the protection of the plaintiff in such a case would be the effect which an allegation of a number of facts which cannot be substantiated would have upon the minds of the jury would be unlikely to believe that the comment was made upon the one fact or was honestly founded upon it.
Yes.
Now, you say that that's not the right test, is that right? Could have been honestly founded upon it.
Yes.
You're saying you don't need to look into the mind of the defendant.
You don't. I think what Lord Porter is saying is that in reality, if someone's put 20 facts down there and he's got 19 of them wrong, that means he's probably didn't have an honest belief in the comment. I don't think that necessarily follows, because you could just make a mistake. But I think it's certainly not necessary for the defendant to prove that he made the comment on that particular fact which happens to be true, because one doesn't get into the subjective stage at this point. There's just a notional honest commentator, and whether that notional honest commentator could express opinion on the basis of that one fact. So yes, that's not entirely accurately stating the position. And of course, the protection for reputation in this case, the safeguard that's there, is that if the facts are defamatory, then the comment defence won't apply, as Lord Denning stated explicitly in London Artis, and I don't seek to rely on this comment defence for anything other than words in the publication complained of which are comment. So it's not the purpose of the civil law of defamation to punish a defendant for getting something wrong. It's not the purpose to set standards of writing in public debate, to enable people to make informed judgments. It's there to provide vindication for a claimant, and any curtailment on freedom of expression should go no further than is strictly necessary for that purpose. Where the opinion does have a sufficient factual basis, but the court prevents the defendant from relying on it to support his comment because another fact has been misstated, the jury again bound to award damages as if the supporting facts did not exist, claimant will be vindicated on a false basis. The only requirement in Section 6 is that there are sufficient facts proved. There is no requirement that all the facts, all the basic facts, all the fundamental facts are proved. There's no such qualification to Section 6, and to impose one would simply create unnecessary complication and restriction. So what did the Court of Appeal do on the facts of this case? We start if we're applying the law in a principled way to the facts of the present case, to recognise that the words will be regarded as comment, at least for the purposes of this argument, we then go to the factual pool. What facts are my clients entitled to rely on? And what were the findings of the Court of Appeal in this regard? Well, there was an explicit finding that the Bibis breach was not referred to in the words complained of. That can be found in paragraph 42 of the Court's judgment. It's dealt with briefly. Clearly, the defendant's real complaint against the claimant was a breach by the claimants of the re-engagement clause in the contract between the claimants and the second defendant. There is no reference to that in the words complained of. The contract is not identified in the publication, still less the term allegedly breached. Moreover, the single specific allegation in the words complained of is plainly untrue. Just to remind the Court, the words in the publication complained of were following a breach of contract. It is most respectfully submitted that Lord Justice Pill was simply plainly wrong on this particular finding. And not only that, he didn't apply the perversity test. He took it upon himself to decide an issue of fact reserved for the jury, because whether words are referred to in the publication must be a question of fact. What is meant by to refer? Well, it means to allude to. It's just a link between the referring words and the matter referred to, which can be very, very brief. It can be uninformative as to the nature of the matter. You can have veiled references, you can have explicit references. To refer to something requires far less information than to state it, to allege it, or to use the words of Lord Justice Pill to identify it. There's also no requirement that the reader of the referring words must have pre-existing knowledge of the matter. or even be in a position to know anything at all about the piece of information from the reference, and possibly even to recognise that a reference is being made. But clearly, this was an explicit reference to a breach of contract, namely the Bibis breach of contract.
The what?
The Bibis breach of contract.
You will remember to speak up.
I'm sorry. One also has to bear in mind that Section 6 emphasises the point by drawing a clear distinction between facts alleged and facts referred to. Both may be relied on in support of a comment defence, and Parliament must have intended a mere pointer to the relevant facts in the words complained of to be sufficient without any requirement to identify them. If it's necessary, I would submit that Section 6 should be construed generously to a defendant in order to enable him to draw from the widest possible factual pool to support his comment, and so far as possible to do so in words of his own choosing. This is consistent with the Strasbourg jurisprudence. But even without that, it's obvious that following a breach of contract is an explicit reference to the Bibis breach of contract. The fact that the reader may not know that the appellant was referring to the Bibis contract, may not know the nature of the breach, does not mean that the appellant did not refer to it. The only possible justification for equating referred to with identified is to enable the reader to be in a position to judge for himself how far the comment is well founded. But as I've submitted previously, this is not a requirement of the defence of fair comment, nor is it a goal to which the law should strive. The next finding was that the landmark breach was also not referred to in the words complained of, and we've gone through paragraphs 43 to 46.
So what do you say is the purpose of Parliament putting in the requirement to refer to facts alleged, of facts alleged or referred to? If you sweep aside, as you say one should, the requirement that the reader should be in a position to judge and so on, what's the point of it?
Well, there may well not be any point at all, but I suppose it is that one could argue this, I suppose, that if someone read this posting, they could go back to either my client or to the respondents and say, well, what was this communication? What was this breach of contract? And find some more out about it if they were minded to be in a position to consider the matter further. So presumably that provides some form of safeguard to reputation. At least there's a possibility of finding out more. And that's why that's the argument, I would say. But my submission is that it's not necessary for there to be any reference at all. I mean, that's my alternative submission.
But you're really rewriting the section, aren't you?
Well, my primary submission is that the facts on which my client seeks to rely were referred to in the words complained of. And that doesn't involve, in my respectful submission, any rewriting of the section. Because if you say following a breach of contract, that's a clear reference to the breach of contract. I simply put forward a wider case, and it's consistent with what's actually being debated at the moment, that there shouldn't be any need for an explicit reference to the facts. Clearly, if the test is that an honest person must be able to hold the opinion on the basis of the proved facts, that must necessarily involve some connection between the proved facts and the opinion, so that the person can hold the opinion. But beyond that, I submit, very much in the alternative, that there's no need for any sort of reference or identification of the facts in the words complained of. And if that was a requirement of the defence, and you could therefore lose the defence if you didn't fulfil it, in my submission, that could have quite a drastic effect on the impact, on the protection that fair comment gives, particularly in the age of the internet, where we've got lots of people expressing opinions without necessarily identifying the factual basis or giving interviews on political matters, whatever it may be. But I'm sorry if I haven't made this clear, but on the facts of this case, I don't need to go further than the ordinary wording of Section 6 of the Defamation Act. That's my first submission. Because all the factual material set out in 9.3 to 9.15 of the amended defence is at least arguably referred to in the words complained of. One cannot say at this stage that a jury would be perverse if they came back at the close of the trial and said, yes, those words following a breach of contract were a reference to the Bibis breach. And yes, that reference, that communication on the 27th of March 2007 was a reference to that email. And if I'm right on that, then I've got all that material in my factual pool, and it is to that factual material that one applies the honest person test. I mean, one could look at it the other way. I mean, what reason is there for excluding the Bibis breach of contract from the material on which my client can rely? Let us suppose, for example, that this was a situation where the band were booked to attend a wedding and they didn't turn up at all. And my learned friend says, well, it's a much more serious allegation than what happened here. But on the logic of Lord Justice Pill in the Court of Appeal's judgment, that the breach of contract still couldn't be relied on because it wasn't referred to. So whether a breach of contract has been referred to can't depend on the gravity of the breach. It's either the reader's not told what the breach was, but let's suppose it was not turning up at a wedding, then my client's not entitled to rely on it to support a common defence. That's the logic of where we are on the Court of Appeal's approach to Section 6. That's the Bibis breach. The landmark breach is the...
I'm puzzled by the same point as puzzles John Dyson. I mean, this Section 6 seems to me, it must be to do with the sentence at the bottom of 357, the top of 358 of Kemsley. But that refers specifically only to the case where the facts are fully set out in the alleged libel. Now, it seems to me that Parliament must have decided that they wanted to reverse the principle he's referring to in relation to situations where it's fully set out, but also, I would have thought, must have seen, well, there may be cases where it's not fully set out, but somehow or others it's referred to, and they want to reverse it in relation to that kind of case as well.
Yes.
Is that what it is?
Well, yes. And for the jury to determine ultimately whether there's been a reference. I mean, the issue of whether something's been referred to is morally neutral, value neutral. I mean,
But it seems to be there was this rule. The rule didn't apply when you didn't. I mean, it didn't apply when you didn't set the things out.
No.
And because, as I understand it, if you didn't do that, then you could bring in anything you wanted.
Yeah. And get most of it wrong as well.
Yeah, well, whatever. But I mean, it's something to do with, I mean, I can't say I've got it fully, but it's something to do with that. It's what it must be that Parliament was dealing with.
Parliament was clearly addressing tolerance of factual inaccuracy in the light of what was said in Kemsley and what was said in previous cases, such as Hunt and Starr. And so in order to permit tolerance of factual inaccuracy, the first question is, well, if you've got something wrong, what other facts can you go to try and stand up your comment?
But was there any case which went wider than what Lord Porter had said in Kemsley and applied this problem, this thing about if you fail to justify one element in a situation which went wider than the situation where it was fully set out?
I'm not aware.
You're not aware.
I'm afraid. I mean, there's.
You make it help us. Right?
I'm sorry. I mean, I can tell you.
No, it's all right. I was just asking.
There's earlier statements of principle. This joint is one case which my learned friend refers to, and there's Hunt and Starr. But in a sense, while it's interesting to see this section coming so soon after Kemsley and Foote, if one just looks at the ordinary words of the section and what is the ordinary meaning of to refer, how can it possibly be said that when you say following a breach of contract, that is not a reference to that breach of contract? It doesn't require the contract to be identified, merely to be referred. So the statute is clear. Applying it to the facts of this case, we have the landmark breach, which is the other breach of contract, it's a deliberate breach of contract on which my clients seek to rely. We've been through the analysis in paragraphs 43 to 46 of the judgment. I pointed out that it wasn't argued in the Court of Appeal, and Lord Justice Pill has presumed that my client's intention to refer to the Bibis contract comes from the words following a breach of contract, whereas our case is that it's at the beginning of this posting where there is arguably a reference to the landmark breach, which is they have not been able to abide by the terms of their contract. That is capable of being understood as a reference to more than one breach. And it would be very unfair and unrealistic, artificial, contrary to the purpose of Section 6, if in the case of serial wrongdoing, a defendant was unable to defend his comments because the one example that he cited in the words complained of could not be proved. It's also
do you accept that the Court of Appeal were clearly impressed by the gap in time,
yes,
the lapse of 17 months, or whatever it was? And you say, well, that's a matter for the jury to assess.
yes.
But would you accept that there might be such an interval of time between the breach and the publication that it would be perverse of a jury to say that the words have not been able to abide by the terms of their contract referred to a breach of contract X years earlier?
Yes, it was very, very many years earlier, and one can envisage circumstances of that kind, possibly. But have been unable to abide by the terms of the contract contemplates more than one occasion of inability to abide by the terms.
Why?
The possibility of it, because it's different from following a breach of contract, is something specific. Have been unable to abide by the terms of their contract is a more general observation, in common with, for example, general meanings and justification situations. One can rely on different examples, a number of examples, to justify the general. It's capable of a general meaning. It's for the jury to decide what they understand exactly by those words, and whether the landmark breach is sufficiently proximate. I mean, as it happens, if you look at my client's witness statement, this was very much in his mind, particularly when one has the observation in the email that you didn't do me, your bookings were fairly limited. You neither helped nor hindered my diary.
What page is the actual posting? I know we've got it in the Statement of Facts and Issues, para 7.
It's to be found in Appendix 2 at tab 3. So that introductory passage is quite general in its wording. Not professional enough, unable to abide by the terms of their contract. again, supposing the landmark breach had been a wedding, they just don't show up at it. Be rather artificial to remove that from consideration just because it hasn't been referred to. I mean, the moral culpability involved in the breach is something that doesn't enter the test of whether it's been referred to. It will enter the test of whether an honest person could express the opinion on the basis of the facts. But the moral culpability, but reference, as I say, is morally neutral. It's said that the landmark breach was fairly trivial, but that goes to a different argument. It doesn't go to the argument about whether it's referred to. The next and final issue on reference is the email of the 27th of March. And if you have the words complained of in front of you still, you can see it's towards the bottom of the page.
Sorry, where are we looking?
If you've still got tab 3 with the words complained of.
Yeah.
Yes, what we say is towards the bottom of the page. The show is an enjoyable solar motown experience which is popular for many events throughout the UK. However, following a breach of contract, Craig Joseph, who runs the Gillettes and Saturday Night at the Movies, has advised 1311 events net the terms and conditions of contracts holds no water in legal terms 270307. So the reader is told of a communication from Mr. Joseph, which includes, not just that, it includes those words, and it was sent on the 27th of March 2007. And I think I probably made this submission earlier, but if the wording had been Craig Joseph sent an email, there could be no dispute if that was pleaded, that there would be a reference to it, such as would entitle the other side to disclosure on the basis that it had been referred to in a statement of case. There's no finding on this issue by Lord Justice Pill in the Court of Appeal, even though it was apparent from the defence that my client was entitled to rely on the entire contents of this email. And I would submit that this email alone is capable of supporting capable of satisfying the honest person test.
What alone?
The email alone, when one looks at it and looks at what these respondents, or this first respondent, was willing to say in a business context.
It is inaccurate to add the S to contract. Yes. It seems to me at least arguable that the quotation accurately reflects what was said in the material paragraph, which was focusing not on one individual contract as I read it, but on the standard form contract that...
yes. And there was nothing to indicate that this contract was any different from any other contract. There was nothing principled about it. I'm very happy to take you through the wording and explain why an honest person could hold the opinion that was expressed on the basis of it. But at the moment, I've got to just try and get it within the factual pool. I'm not being allowed to use it at the moment as the basis for my comment. And I'm saying that it clearly was referred to. And it would be, again, artificial, wholly contrary to Article 10 and unjust if there was some citation from a document that was wrong, whereas there was ample material within the document itself to stand up the comment. That the defendant's fair comment defence failed. We have a situation here where this email, I'm entitled to rely on it to show that the respondents have a cavalier approach to contractual obligations, contemptuous approach to contractual obligations, and may not adhere to their contractual bookings. So I'm allowed to rely on it for justification, notwithstanding it's been misquoted, but as far as fair comment was concerned, I'm not allowed to rely on it at all. There's things in that email along the lines of, I signed the contract and the other two are playing, so it's nothing to do with me. Go back a page, I think you'll see the email. Hi Jason, it appears you do not know the meaning of freelance. That is what all my shows are. You are part of a cog which supplies all agents and artists alike with work. One does not work without the other. Well, fair enough, but isn't that a reason for honouring contracts rather than breaching them? The respondents didn't have to take this very well-paid concert at Bibis on New Year's Eve. They didn't have to sign a contract if they didn't want to play, but they chose to sign it. You came to me, Jason, after viewing the quality of our show. Your contract is merely a formality and holds no water in legal terms. What does that say to somebody? And the admitted facts are that there was a deliberate decision not to tell my client about the re-engagement clause. Conscious decision not to do so. When it's drawn to his attention, does he say sorry? Does he try and find a way of dealing with it? No, he comes up with some ridiculous excuse that the contract is a formality because my client came to him after viewing his show, which is ridiculous. The next sentence, you should consider looking after your client's venues better, then maybe you would not lose them. That's supposedly a reference to Bibis, but that's very much an issue in the litigation. There's no evidence that my client had any falling out with Bibis. There's no witness statement from Bibis. And even if there had been a falling out, which there wasn't, he could have just simply agreed to pay the commission over. Don't be fooled into thinking you can lose venues and reap the benefits from others' hard work. That does not hold any legal value anymore. Your offer of work to my shows over the years was minimal and neither helped nor hindered our diary. You're an unimportant person, in other words. I can mess you around if I want to. And then this is just classic. I'm not performing in the show, and since your agreement and terms with me, there are no grounds for your terms and conditions. This is a man who signs a contract as the manager of the band, as a performer, and then on behalf of the band, and then seeks to wheedle it out of it on the basis he says he's not performing. And that shows quite a level of resort to trickery and deception. And it shows that he must have been fully aware that the re-engagement clause was binding, otherwise he'd have no reason to resort to this. And we say, anyway, this is all artificial, because he was going to play in the show, we say. And this is just being put forward as just an excuse to get round. Would you want to book a band who sends out an email like that, when asked rhetorically? Would that not perhaps make you think that maybe these guys are less than professional, maybe they might not honour their contractual obligations? If it doesn't suit them, they might try and find a way out. Anyway, whether it's a reasonable or unreasonable opinion, it's certainly one that a jury could conclude, that an honest person could hold. And it's a classic jury question. And there's a real danger when lawyers look at misquotations to attribute too much to them. It's really what a jury concludes from looking at this email in the context of the respondent's conduct and the other matters on which we seek to rely. So I submit that all these facts are at least capable of being referred to in the words complained of. And then we come to the final part of the test, insofar as we're talking about the relationship between the facts and the comment. And the final part of that test is, could a reasonable jury conclude that an honest man could express, on the basis of these facts, the opinions that are set out in paragraph 10.1 of the amended defence? The Court of Appeal did not ask itself this question. possibly it asked the question in relation to just the landmark breach in isolation, but it certainly didn't ask it in the context of all of the...
Well, it didn't get to that stage,
No.
because it cut them out, so you don't really need to deal with that.
No, no. The only answer is clearly that could happen, and bearing in mind we've got a justification defence which is properly arguable, which could entitle the jury to conclude that as a fact they may not adhere to their contractual undertakings. It's very difficult to see how that test could not be satisfied for the purposes of fair comment. And similarly, if I've got to deal with a higher hurdle, if I've got to show that the basic facts were right, if I've got to show that the basic facts were substantially true, I submit that my client has a real prospect of doing so, and that's implicit in the fact that Mr. Justice Eady allowed the justification defence to go before the jury. And that implicit in that is that the facts were substantially true. A jury could regard the misquotation of the email as not being substantial in the context of everything else.
As matters stand with your fair comment defence struck out, if you succeed on justification, do you succeed in respect of justifying the comment too?
Well, I'll have to do that. But it's a much...
And you pleaded justification of the comment as opposed
Yes.
to the... Where do you plead the justification of the comment?
It's in...
I'm looking in, obviously, tab 6.
Yes. It's paragraph 9.2 on page 19. That's really the sting of it, that the claimants may not necessarily adhere to the terms of booking agreement signed by the first claimant. That's equivalent to... It may follow that the artist's obligations for your booking may also not be met. In essence, Craig Joseph, who performs with arranges bookings for the Gillettes and Fashion Item movies, may sign a contract for your booking but will not necessarily adhere to it. That's the comment. It is perfectly permissible to seek to justify a comment. And there's a case called Sutherland and Stopes, the House of Lords decision, which makes that clear. But obviously, from a defendant's point of view, it's much more attractive to be able to rely on fair comment, because where justification is concerned, one has to prove that the comment is correct. Whereas, as far as comment is concerned, one merely has to prove that an honest person could hold the opinion on the basis of the facts. That's why I'm here today, to seek to reinstate the comment defence. I've put forward a much wider case in the written case. I don't dealing with issues such as malice and public interest, and I can see that I've already taken quite a lot of time.
You have, and this court is unlikely to go further than it needs to in this particular appeal.
I'm grateful. So unless I could be of any further assistance to the court, those are my submissions.
No, thank you very much. Mr. Coulter.
Well, can I take your Lordship's last observation as a cue?
Yes.
To focus on what I perceive to be really three related issues of importance. An obligation or otherwise to...
Where are you taking it?
My Lord, I'm just trying to identify what I understand to be the three issues which your Lordships are directly concerned with. My case looks at a number of other aspects
Indeed,
of the defence of opinion which causes the media interveners a degree of anxiety. But my Lord Phillips is obviously right that there's been a focus today on three issues important enough in themselves, and I was certainly going to start by focusing on them. They are, if I can just summarise them, whether or not there is an obligation to refer to, at least in general terms, any facts in the words complained of, if the commentator is to be free to rely on them. Secondly, this is less important to the parties, but very important to me and very closely related, whether the commentator has to know the facts. And I'm going to, if I may, take the liberty of dealing with that related question.
And thirdly, section 6, where I do have a very different submission to make to that advanced by Mr. Price. We have a very different solution to section 6 as a matter of construction, which I do want to address your lordships on. If I may just have 3 or 4 minutes by way of general introduction to set the context to these problems. 2 core difficulties have confronted the law of opinion. The first is a threshold question of setting the boundaries for what opinion in this context means. The second problem is what safeguards or mechanisms are needed to protect reputation from the effect of defamatory opinion as so defined. So the first is the threshold question of what is opinion as opposed to fact. And secondly, insofar as you're dealing with opinion, what are the safeguards, mechanisms required for reputation? Critical to the second question is that this is a tort about vindication of the claimant's reputation. It is not about disciplining publishees as to accuracy or matters of that kind. The tort exists to vindicate reputation and nothing else. And it's an important matter which I will have to come back to later, particularly in reference to the reference and knowledge issues. Now, the first question, in some cases, is easy, and in some cases is not. In cases of artistic criticism, it's very easy indeed. It's the play or the novel or the published work. But in conduct cases in particular, it can be much more difficult. The first question is very important for this reason. Could I just take your lordships to a short dictum of Lord Justice Bingham in a case called Brent Walker at tab 4 of volume 1 at page 44 F to H. And it starkly emphasises the enormous importance of what tools are to be used to distinguish fact from comment. Just below letter F, Lord Justice Bingham says this: the civil law of libel is primarily concerned to provide redress for those who are the subject of false and defamatory factual publications. Thus, in the simplest case, A will be entitled to relief against B if B publishes a defamatory factual statement concerning A, which B cannot show to be true. The law is not primarily concerned to provide redress for those who are the subject of disparaging expressions of opinion. And freedom of opinion is subject to necessary restrictions, a basic democratic right. Now that underlines the great importance of what are the tools whereby one is to distinguish factual statements from statements of opinion. It won't surprise your lordships appearing for the media that I would say that it's even more than a basic democratic right. In our historical section, it's page 40 of our case. And this is as long ago as 1868. There is a valuable statement by Chief Justice Cockburn in a privilege case called Wason and Walter.
I'm sorry, where
No, sorry, Lord, in my case, it's not in your lordship's bundle, it's at page 40, and the citation is set out in paragraph 5 of our historical section, right at the back of our case, at page 40. And the only point I wish to make from Chief Justice Cockburn's statement is that it's not merely that there's a right to express opinion, but that on public interest issues it is positively to be encouraged. And it's really the last 5 lines of that citation. Yet who can doubt that the public are gainers by the change, and that though injustice may often be done, and though public men may often have to smart under the keen sense of wrong inflicted by hostile criticism, the nation profits by public opinion being freely brought to bear on the discharge of public duties. And one only has to think about it a little deeper to see that there are a host of public benefits which arise from encouraging debate on public interest issues. Disinterest and apathy in public interest issues tends to arise if there's not enough debate. There's no law governing complementary material. In an age of spin, there's a lot of inaccurate fact, mixed fact, on which praise is based. If you start to chill the effect of corrective adverse opinion, the danger is that, as it were, the public wheel of debate gets too one-sided. However, as I equally recognise, the protection of claimants from defamatory allegations of fact does remain a core function of the law of libel. The defence of fair comment does not trespass upon that concern at all. The defence of fair opinion or honest opinion provides no defence whatsoever to a defamatory statement of fact which is either expressed in the words complained of or an inference which the reasonable reader of them would draw. It's absolutely fundamental to have that in mind. Because listening to this case, there are times when one thinks that that line is being blurred. Can I also mention this intrusive and difficult word fair, and just help your lordships as to where it appears to have come from? In the 19th century, fair comment was regarded synonymously with privilege in the conventional sense of special circumstances in which people had a duty and reciprocal interest in communicating employers' references, doctors and patients, reports, all matters of that sort. And the classic statement of privilege in its earliest days included the word fair. In fact, it includes it twice. And I'm just going to show it to your lordship very briefly about this, but it is an interesting explanation of the origins of, it's caused so many problems in this area, that it might just be helpful just to indicate its provenance. Lord, it's the founding case of qualified privilege in its strict sense, so understood, called Too Good and Sparring. A case that was decided in 1834. Appreciate that at this stage, fair comment has not emerged as a discrete defence. It is simply regarded as part of privilege. It's only in Campbell and Spottiswoode in the 1860s that the defence of opinion emerges as a distinct creature.
So it was what case?
Campbell and Spottiswoode, which is in the bundle, and I think it's 1865 from recollection. Now, there are two things notable about this statement. Your lordships will again see the focus on statements of fact as being the main concern, and your lordships will also see the word fair. Bottom of page 1049, this I hasten to add is a landlord and tenant issue where there plainly was reciprocal duty and interest between publisher and publishee. The very bottom of 1049, about 4 lines up, in general an action lies for the malicious publication of statements which are false in fact and injurious to the character of another within the well-known limits as to verbal slander, and the law considers such publication as malicious. Just to pause there, that means without lawful excuse, not actual malice. Unless it is fairly, notice that word, I've got this copied volume, fairly made by a person in the discharge of some public or private duty, whether legal or moral, in the conduct of his own affairs, in matters where his interest is concerned. Then we don't worry about the next sentence, but the final sentence of that paragraph, if fairly warranted, by any reasonable occasion or exigency and honestly made, such communications are protected for the common convenience and welfare of society. Now, what the law came to realise was that in relation to comments, some further mechanism was needed. In other words, it wasn't simply enough just to show an honest belief. But that word fairness crept in to the sluice gate, as it were, and caused a lot of difficulty. Your Lordships may find at volume 1, tab 26, an observation by Lord Collins, Master of the Rolls, in a case called Macquarie, helpful on this point as well. And I'm not going to, it's quite long, I'm not going to read it all, but page 112, tab 26, volume 1 of the Authority Bundle, Macquarie against Western Morning News. He deals there briefly with a privileged occasion, but almost right in the middle of the page, just one line above the word Genesis at the edge of the page. I think these considerations throw some light on the genesis and meaning of the word fair in the expression fair comment, which is not of merely recent origin and coexisted with the view that the doctrine of privileged occasion applied to such cases. The comment, in order to be within the protection of privilege, had to be fair, i.e. not such as to disclose in itself actual malice. One of the problems is that this word fair has been attached at different times to different parts of the test, and therefore has caused a fair amount of confusion. But I just mention that by way of background. Now, can I go to the first threshold question? We respectfully suggest that there is one requirement, not always easy to answer, but one requirement only, which is that the statement is and is recognisable as opinion by the ordinary, reasonable reader, listener, or viewer, as the case may be. In other words, this question is looked through the prism of the ordinary, reasonable publishee. Same prism, incidentally, whereby the meaning of the words is judged in defamation law for the purposes of justification or fair comment. The best description of what an opinion is now generally regarded as being that of Mr. Justice Cusson in a case called Clark and Norton in the Australian cases, but it's cited in Burstein at tab 2 of our first volume, at paragraph 19. It needs one, I think, subtle refinement, but apart from that, it's generally regarded as the best statement, and it was approved in this case, and indeed in Branson and Bauer in the Court of Appeal. Just but few lines into paragraph 9, that's Ms. Sharp, relies upon the often quoted statement of Mr. Justice Cusson in Clark and Norton, approved by the Court of Appeal in Branson and Bauer. More accurately, it has I'm sorry, my lord.
Burstein, paragraph?
Paragraph 19, my lord. I'm sorry, maybe only my fault.
Yeah.
Paragraph 19.
Yeah.
And the citation is set out there. More accurately, it has been said that the sense of comment is something which is, or can reasonably inferred to be, a deduction, inference, conclusion, criticism, remark, observation, etc. It's only a personal perspective, but perhaps what matters is that it's recognisable as one of these things and not as a bald statement of fact. Now, Lord Oaksey in Kemsley observed that the forms in which opinion may be expressed are infinitely various. And it is in our submission dangerous to start creating sub-models when this single test is, we would respectfully say, satisfactory. But there is one point that is basic. An opinion must be based on something. And one of the most difficult issues in this appeal is how defined does that something have to be? We would respectfully suggest that two things have to be looked at very closely. One is content of the words complained of, but the other, as the Kemsley case clearly demonstrates, is context. Now, we respectfully suggest that what has happened in some of these cases, and I will come later to what we say is a very important judgment which has caused a fair amount of the difficulty, which is Lord Justice Fletcher Moulton's judgment in Hunt and Starr, where I suspect Lord Nichols may have got some of his material from. I'll try and follow it through. But that judgment may well have been responsible for a fair amount of the difficulty. So that is the first question looked at for the moment very briefly, what I call the threshold question of trying to identify whether it's a comment. The second question, what are the safeguards for reputation, has basically two ingredients. The first is an objective test, and I stress the word objective. It's nothing to do with the commentator's state of mind at all. It derives from Lord Isher's test in Merivale and Carson, with the amendment to honest from fair, which was proposed by Lord Porter in Kemsley, and it's encapsulated in our suggested principle 2 in our case. The Lordships will remember that at the end of our case, we list certain suggested principles, and this is principle 2 on page 36 of our case, which broadly reflects Lord Isher's test, but replacing the word fair with the word honest. The opinion will qualify for protection if any person, however prejudiced, exaggerated, or obstinate his views, could have honestly expressed it on the proved facts or on alleged facts protected by privilege. I'm not sure that my phrase alleged facts protected by privilege is a very satisfactory one. Perhaps privileged material would be better. Lord, that test was confirmed by Lord Keith in Telnikoff, and it is always in the textbooks regarded as the basic formula for the objective test. Now, the second test is subjective, which is the question of malice, whereas the objective test is concerned with a notional honest man and what he could have honestly derived from the proved facts. The subjective test is concerned with something entirely different, which is the commentator's honesty and his intentions as to meaning and his understanding of the facts, right or wrong. Now, we submit, with the greatest respect to Lord Nichols, of course, that two related and unnecessary complications have been imported into the objective test. The first is that the facts must be referred to, or at least indicated in general terms, in the words complained of. There is no such limitation in Lord Isher's formulation, and we'll have to look at where it may have come from. But that's the first one. And the second is the closely related suggestion that the facts must be known to the commentator, with this rather strange philosophical refinement that not necessarily at the forefront of his mind, whatever that means. Now, the two are connected for this reason. If the commentator has to indicate the facts in at least general terms, he is likely to know them, or at least to know their gist. Now, we respectfully suggest that these requirements have evolved from a mistaken elision of two quite distinct aspects of the case. The first is sufficiently indicating by content or context the subject matter, I stress the words, the subject matter of the comment in the publication complained of, so that it is recognisable as comment and passes the threshold test. The second position is this: assuming that is achieved, it is, we submit, and it's clear from Kemsley, that it is this specified subject matter which determines what the range of facts which may be relied on as germane to the comment. To take a big point early, and Lord Phillips highlighted this problem very early on in the argument. As an intervener, I'm trying to take examples not on these facts. Can I take an example of a comment which says that politician X gave a speech on a Wednesday in which he made comments which I consider to be racist? Let us assume for the moment that I am completely misinformed about him having made any such speech, but 2 weeks earlier he published a leaflet which says almost substantially the same thing, on which the comment would be entirely within the objective test. Bearing in mind that we are concerned with vindication, that's what this tort is about, how on earth can it be right in a system which should encourage debate of that sort of system that the politician should obtain damages merely because I've specified a speech when I should have specified a leaflet? That actually is the most telling example as to why setting out the specific facts cannot be the right test. It also immediately suggests that Lord Porter's emphasis on the subject matter, namely in this case, shall we say for the sake of argument, what he has said about immigration, subject matter, is the right test, because the first formula sets the factual envelope too tightly. To put it crudely, the claimant will obtain a wholly undeserved vindication, merely because the facts are wrong. The fact in the piece is wrong.
That's fine if the comment is actually justified by the piece. But it seems to me it's a bit tough if the politician is going to be saddled with a completely bigoted, unreasonable comment, which hasn't actually got any basis for it at all.
Well, there is a subtlety here which is quite difficult. Plainly, supposing I set out in my piece what he said, and supposing this is a case where on the face of it, it is a racist statement. Now that becomes a defamatory statement of fact, which I would have to prove to be true. And the law now is that if in substance I could prove that he's made at or about the time of publication racist statements, he's going to fail even though that statement of fact is wrong. If it's clear that it's an opinion and there are room for different views about the quality of what he said, I mean, he may be just very strongly opposed to further immigration. Some people may take the view that is racist, some certainly would not. It's within that kind of area of debate. If it's a non-defamatory fact in the sense that people just, that's what he said and people could differ about it, there is really no objection to him simply being saddled with a bit of factual inaccuracy. Or put another way, it's not the role of defamation to compensate him for that fact. The lurking safeguard, which is always there, is that the moment the full statement in the words becomes defamatory and is factual, it has to be proved. Now, your lordship may be right that one can think of opinion cases where a degree of harshness may come in, but that we would respectfully say is within what Lord Ellenborough contemplated as really one has to allow for some give or take to get the benefit of public discussion. Now, my Lord, that's the... can I now deal with where we suggest, or there are a number of places where one can see where what we call, respectfully suggest, is the wrong view may have come from. Can I just give your lordship some references before going to them? Firstly, there is Lord Justice Fletcher Moulton's judgment in Hunt and Starr, which Lord Porter in Kemsley said was the only real judicial basis for suggesting that facts have to be set out in the words, and in fact it's effectively disapproved of in Kemsley. But to complicate matters, Lord Porter also cites with approval a long passage from Odgers on pleading and practice, which includes a very short passage which could be read as suggesting that the reader must be in a position to know whether he agrees or not. I'll take your lordship to it. But it's plainly not for that purpose that he's citing it. I'll take your lordship to the previous edition of Duncan and Neal, which Lord Nichols refers to in Reynolds. And lastly, there is a short passage in the Folks Committee report, which again certainly can be read as supporting that view, which I'll come to. Now, my Lord, can I start, if I may, with Hunt and Starr? The case is not satisfactory for a number of reasons. One is because it's one of the cases which contains what we call the dishonourable motive exception for fair opinion, fair comment, which almost everybody now regards as hopeless and completely restrictive. And we've dealt with it fully in our case, and I'm not going to spend time on it now. But that's one reason why this case is not entirely satisfactory. But and it is only, I emphasise, really the judgment of Lord Justice Fletcher Moulton that causes the difficulty, and it's mainly at page 319.
Sorry, which tab is this?
Lord 14 of the first volume.
319, is it?
319, please, yes, in the middle. Just above the middle, your lordship will see what I say is the motive heresy, born of a time when this country was plainly very concerned by attacks on public men, and that principle now we say is no longer good law. It's just above the break, but I'm really more interested at the moment in the new paragraph starting halfway down. The laws to fair comment as far as material to the case stands as follows. In the first place, comment in order to be justifiable as fair comment must appear as comment and must not be so mixed up with the facts that the reader cannot distinguish between what is report and what is comment. Now, just pause there. He's here dealing with the question of what is comment, the threshold question. This is one gets a constant tension between these two quite different questions. The justice of this rule is obvious. If the facts are stated separately and the comment appears in inference from those facts, any injustice that it might do will be to some extent negative by the reader, seeing the grounds upon which the unfavourable inference is based. But if fact and comment be intermingled so that it is not reasonably clear what proportion purports to be inference, he will naturally suppose that the injurious statements are based on adequate grounds known to the writer, though not necessarily set out by him. In the one case, the insufficiency of the facts to support the inference will lead fair-minded men to reject the inference. So your Lordship will see that there's a hint there that readers should be able to tell whether they agree or don't agree by the facts being set out. It's actually dealing with a different question of how do you identify comment. And then at 119 in Kemsley, I mean, we've looked at this already and quite fully, and I'll have to come back to it when dealing with section 6. 356, the second new paragraph. There your Lordships will see the question therefore in all cases is whether there is a sufficient substratum of fact stated or indicated in the words which are the subject matter of the action. And I find my view well expressed in the remarks contained in Odgers on libel and slander, 6th edition, 1929, at page 166. Sometimes, however, he says, it's difficult to distinguish an allegation of fact from an expression of opinion. It often depends on what is stated in the rest of the article. If the defendant accurately states what some public man has really done, and then asserts that such conduct is disgraceful, this is merely the expression of his opinion, his comment on the plaintiff's conduct. So if without setting it out, he identifies the conduct on which he comments by a clear reference. And then this is the slightly problematic 2.5 lines. In either case, the defendant enables his readers to judge for themselves how far his opinion is well-founded. And therefore, what would otherwise have been an allegation of fact becomes merely a comment. But if he asserts that the plaintiff has been guilty of disgraceful conduct and doesn't state what that conduct was, this is an allegation of fact for which there is no defence but privilege or truth. Now, Lord, what I understand Lord Porter to be citing that passage for is that you do have to have sufficient indication of the subject matter to make it a comment. But what he's not citing it for is that the facts have to be set out in order for the reader to be able to judge whether he agrees or not. But I do readily accept that there are 2.5 lines in there, those 2.5 lines which can be regarded as of difficulty. And then it's helpful to go on to page 357. And this is slightly, again, picks up the point my Lord Phillips made about context. He's still dealing here with the threshold question 1, is it opinion or not? But the question whether an inference is a bare inference in this sense must depend on all the circumstances. Indeed, it was ultimately admitted on behalf of the appellant that the facts necessary to justify comment might be implied from the terms of the impugned article, and therefore the inquiry ceases to be, can the defendant point to definite assertions of fact in the alleged libel upon which the comment is made, and becomes, and here's the crucial subject matter passage, is there subject matter indicated with sufficient clarity to justify comment being made? Now, this was an acute issue where the words were lower than Kemsley. Not a single article, and indeed, in fact, Lord Kemsley owned 3 papers at the Times, the Sketch and the Daily Graphic. It wasn't even identified which newspaper they were talking about. But what was at least clear was that they were talking about a body of journalism in Lord Kemsley's newspapers, and it was firmly held by Lord Porter that that was a sufficient indication of the subject matter. Now, the indication of the subject matter therefore has a dual purpose. Firstly, it may be very important in answering the question, is this comment or is it an allegation of fact? But secondly, it has this purpose, assuming it's sufficiently specific to get you over the first hurdle, it then defines the factual envelope within which a defendant can rely on facts. Now, the point was raised, it's just one example of several one can think of, about temporal problems. I think it was Sir John Dyson who raised this issue. Supposing you said that someone was untrustworthy on account of his dealings with other people's property, and you said it when he was in his 40s, the fact that he'd stolen something when at school would not be germane to the comment, because the comment is his character at the time of publication. That's the factual envelope. Now, there may be difficult cases placing whether the fact is in or outside the envelope, but certainly one can envisage that there is a temporal boundary. There are other kinds of boundaries as well, but that's certainly an example. Now, my Lord, I may as well deal with it because it's crucial when I come on to section 6. I'm just going to deal with it as we're here. But with great respect to the appellants, we say they're making their task a great deal more difficult than it really is. They're struggling to get themselves into facts referred to in the article. But what, with respect, they're overlooking is that both the Defamation Act 1952 is not a codifying act. It's an act which is seeking to improve the common law in a number of specified respects. In relation to justification, the problem was that if you accuse someone of murdering his father and striking his mother, it was no defence to striking his mother to prove that he'd murdered his father at common law. Section 5 was specifically put in to deal with that multiple charge problem. No reputation left when you look at the one that is proved, but at common law that was a problem. That's what Section 5 was dealing with. Section 6 was not dealing with the whole law of the facts you can rely on for fair comment. It was dealing with one particular common law problem, which was that the position appeared to be that if the facts were set out in the words, you had to prove all of them or fail. And it was that particular rigorous, unduly harsh common law rule that Section 6 was brought in to mitigate. It was in no way abrogating the other common law rule that if facts are relied on which are not set out in the words, you only have to prove enough. You don't have to prove all the ones that you put in your particulars. I have to say that the historical origins of the distinction are quite difficult to understand, but there it is. There plainly was that distinction. Kemsley was extremely topical at the time the 52 Act came in, not least because it had already been in the Court of Appeal, and the speeches were almost contemporaneous with the actual final readings of the 52 Act. It might be helpful if I just read on this page, just while we're on it, to highlight what Lord Porter says. He deals with the Section 5 problem at the very bottom of page 357. In a case where the facts are fully set out in the libel, can I just say for a moment, one has to read in the defamatory facts set out in the libel. Each fact must be justified, and if the defendant fails to be justified, one, even if it be comparatively unimportant, he fails in his defence. So that's the justification problem, the defamatory statement of fact problem. He then goes on to deal with the fair comment related problem. Does the same principle apply where the facts are found not in the alleged libel but in particulars delivered in the course of the action? In my opinion, it does not. Where the facts are set out in the alleged libel, those to whom it is published can read them and may regard them as facts derogatory to the plaintiff. Well, pausing there, if that's right, they've got to be justified. If they're in the words complained of, they've got to be justified, so there's no hardship to the claimant there. But whereas here they're contained only in the particulars and are not published to the words at large, they are not the subject of the comment, but the facts alleged to justify that comment. Now, the use of the word justify, again, is unfortunate and it does tend to complicate. He's here talking about fair comment, not justification. In the present case, for instance, the substratum of fact upon which the comment is based is that Lord Kemsley is the active proprietor of and responsible for the Kemsley press. The criticism is that the press is a low one. As I hold, any fact sufficient to justify that statement would entitle the defendants to succeed in a plea of fair comment. 20 facts might be given in the particulars and only one justified, but if that one fact was sufficient to support the comments to make it fair, failure to prove the other 19 would not of necessity defeat the defendant's plea. And then there are some observations, and then he goes on to deal with motives. And then your lordships will see the emphasis given to Lord Justice Fletcher Moulton's judgment at the top of page 359. He says that's the main support for the appellant's argument. The appellants were arguing there are no facts set out here. It just says lower than Kemsley. You haven't set out any facts, therefore you must fail. And then he derives that from Lord Justice, and then he doesn't uphold it. And my Lord, can I just digress back, if I may, briefly here to an observation that I do want to make about vindication. Assume, hypothetically, that citizen A and citizen B are contributing to a debate on a public interest issue. Assume, for the sake of argument, both of them are honest. They both make substantially the same criticism of the claimant, but one is much better informed as to the background facts than the other. And indeed, citizen B, for the sake of argument, is so misinformed that on the facts he happens to know, he wouldn't pass the objective test. But why, one asks in vindication terms, should the claimant get a vindication against one but not against the other, where the sting is the same, where it's in the public interest to have the discussion and they're both honest? If someone objectively on the objective test could express such a criticism, why should the claimant be entitled to vindication? And that is why we say that this intrusion of having to set the specific facts out in the article or refer to them in general terms doesn't really fit the purpose of the tort. If, of course, the facts are defamatory, then you have to prove them, absent any privileged defence. Now, my Lord, the question of knowledge, we respectfully say, is an even greater heresy, because the first test is objective. It has nothing to do with what the commentator knows. The safety valve of honesty is in the second stage, which is the malice stage, when you look at the state of mind of the commentator. But the first stage is objective. And this again relates to it's why that rule, it fits entirely my citizen A, citizen B example as to why the claimant shouldn't get vindication. If there are facts out there on which the comment could perfectly properly be made, and assuming citizen B is acting honestly, why should it turn simply on what facts he knows? Now, as another objection to this, perhaps it's simply another way of putting the same point. If at stage one, the objective test, A commentator has to show he knows the facts for the facts to qualify. Assuming he passes the objective test, and he has to pass it in order to get to malice, what is the scope for the malice inquiry? He knows the facts pass the objective test. Why is his knowledge, it makes no sense to look at his knowledge under stage 1, because if you do, there's nothing left for the subjective inquiry in stage 2. Now, my Lord, we do have one or two other concerns about section 6. One is a very small one, but I just want to deal with it. So your lordships are looking at it. It might be worth just briefly mentioning. We do allude to it in our case. Section 6 is volume 2, tab 39. Lord, it's simply this point that if you read it literally, it's only facts which are referred to in the words complained of which qualify. There is a lurking problem here, because your lordships may know, and this is partly why this area of the law causes so much trouble, claimants quite often edit the words to take out the facts that are true, or the statements they'd rather not complain of, and leave in the ones which they do challenge. Now, plainly, if you take the words complained of in the last line and the words in respect of words in the first line too narrowly, you end up with a nonsense. So I only just mention that point because it might be worth dealing. It plainly means that...
Hasn't any case yet said that you can't possibly do that? It's ludicrous.
Lord, I'm not convinced that any claimant or plaintiff has had the nerve to try yet, nonetheless, it may be as well to lay it to rest before someone does.
I'm not sure I've quite yet grasped what the point of section 6 is.
Well, my Lord, it's only this, and the reasons for it are not entirely easy to see, that the common law rule appeared to be, if you rely on facts which are not referred to in the article, you can prove only one. That's enough. That's good enough. But because you've told the reader about the facts which are in the article, you must prove all of them or fail. Now, that appeared to be the common law position as Lord Porter saw it. And he, understandably, appears to have thought, well, that doesn't seem to be right. Surely that needs to be modified. If you prove sufficient facts, that's enough. And that's how I understand the purpose of the section to be.
What is the purpose of... Because I'm sorry, I may not have understood, but what is the purpose of the referred to? I mean, was there... because he seems to contemplate a situation where you actually put out the fact, you set out the fact.
Well,
and
I think what he has in mind are, first of all, where you set out the facts, or secondly, where you say, in the light of what he says on page 47 of his book, it's a reference.
It's just to cover that.
It's to cover that. It's what I would respectfully suggest it is. It's incorporated by reference.
It would make sense, because otherwise it would be ridiculous.
But with great respect to my learned friend Mr. Price, where it does become a problem is when you try and squeeze into the words referred to in the words complained of any fact which qualifies. Because you then sooner or later find yourself trying to face in two directions. And it's solely concerned with the problem of the readers which you've told the reader about, either expressly or by reference. That's what I would suggest.
But if you haven't bothered to tell the reader at all what facts, then you're hunky-dory, are you?
Well, that is, in some ways, I think to many, that is a curious philosophical base, but it's what it plainly was. And it does appear to have been mixed up with the idea that that it's less damaging when it's not being read, but of course it all comes out at the trial, one might well say. And why give a defendant more width when he's not, he's told you less? But your lordships will see this difficult correlation between the subject matter for the purposes of deciding whether it's an opinion at all. And once you're through that, the subject matter, in a sense, determining the factual envelope as we describe it. Lord, we set out in our case a number of passages from Kemsley which all refer to subject matter as being the key. That there are paragraph 53. And can I just draw your lordship, just to save you having to go to the bundles, and we then finish with what Lord Keith said in Tolnikov, which is again the same. This is a very important statement, this by Lord Keith. There can be no doubt that where the words complained of are clearly to be recognised as comment, and the subject matter commented on is identified, then that subject matter must be looked at to determine whether the comment is fair. In other words, what he means is when you're applying the objective test, it's the subject matter that delineates the boundaries. Lord, I ought to give your lordships, I think, the old edition of Duncan and Neil to which Lord Nichols was referring in Reynolds. Can I just pick up a point that I think Lord Walker made? It's absolutely right that both the references in Reynolds to honest opinion don't include the agreeing with point. They don't include that jurisprudential reason for setting out the facts. They appear for the first time in Chain. Lord, I was in Reynolds and there was no discussion about the fair comment test in Reynolds. It was entirely concerned with what was a big enough subject in itself, which was this whole question of whether there should be a generic privilege for political speech or a responsible journalism privilege, and it ended up, as we know, as responsible journalism. Lord, I haven't completely finished going through.
So what's the date of this earlier Duncan and Neil?
Lord, it took them an age to produce the latest edition. It's 1983. And the new one came out, I think, last year. The next edition. Is that the one he cites, 1204? Lord, the Duncan and Neil's changed its position quite radically since this edition. 1205. It's 1205 that your lordships need to look at page 58. It is, and again, you can see the problems with the two different tests. It's a necessary ingredient of fair comment that the comment shall be based on facts which are either stated by the commentator or indicated by him with sufficient clarity to enable the reader or listener to ascertain the matter on which the comment is being made. And then there's a leap.
But you accept that?
Yeah.
Yes, I do.
That's your subject matter?
Yes. But then there's a subtle leap. A defendant cannot defend a statement as comment, however, if he has not set out the facts on which he based the statement, nor at least indicated in general terms what those facts were. But the citation here is in fact dealing with the different question of what is recognisable as opinion. As your lordships will see, as opposed to the factual envelope once that's done sufficiently. Lord, I ought in fairness just lastly to take your lordships to one brief reference in the Folks Committee. The question was asked this morning about where one might find some support for this proposition. Volume 2, tab 41, at 172. This is on the separate question about knowledge. penultimate sentence of
Sorry, paragraph
tab
what?
41 of volume 2.
Yeah, I got the tab. What?
It's page 44,
44.
paragraph 172.
Yeah.
And it's that one sentence. He may rely on other relevant facts, provided they were in his mind when he made the comment. Now, my lord, that one strongly suspects came from the case of Cohen in the Daily Telegraph, which itself discusses a Scottish case called Wheatley and Anderson, and we'll have to look at it a little bit to understand the origins of this knowledge rule, which we say that case doesn't really come close to establishing. But that appears to have been the basis for it. Can I just take your lordship to Cohen, which is tab 9 of volume 1. Lord, this was a fair comment case where the facts were struck out by the judge and the order was upheld by the Court of Appeal. And the plaintiff was a man who rescued ailing companies. And the words complained of are at page 918 between D and F. And they include the words, "It doesn't inspire confidence in Dr. Cohen's remedial powers." Now, most of the facts relied on were pre-publication, and your lordships will see that at letter G, most of the facts pleaded took place before this article was published on May the 19th, 1967. Again, a lot of these facts were not set out in detail in the words. 919A is Lord Denning's pithy observation, which, with respect, we think is right, that you really can't comment on facts which haven't happened. And indeed, once you start introducing a rule whereby you can rely on facts that haven't yet happened, there's serious potential unfairness both to claimants and to defendants, we say. They plainly must be facts which bear on the position as at the time of publication. Now, he then...
So, wait a minute, I mean, I know you're not going to deal with the fact of our case, but then you don't deal with Coombs booking in our case, is that it?
Lord,
No, all right, well.
No, Lord, I find it very difficult to get involved without evincing a view, which I think I probably shouldn't.
Very well.
Now, my Lord, can I just briefly say a little about justification? There is, in fact, one further dictum which makes it very clear that even in justification, although you can rely on later facts, they have to be facts that tend to prove the charge at the time of publication. That is, in fact, the rule in justification. So what this case was mainly dealing with, in fact, exclusively dealing with, was the ability to rely on facts that had not yet happened, and they upheld the judge's view on that. But in the course of it, and it's particularly in Lord Justice Davis's in judgment, but I ought to deal briefly with what 919H. The judge thought that those cases, this is the justification cases, had no application to a plea of fair comment. I agree with him. He's cited two justification cases, Maisel and Godman. Maisel is a case where they say this is just the kind of man who would practice this kind of fraud. And they were then allowed to rely on him actually doing that kind of fraud a few months later, unsurprisingly. So it was the allegation was about a propensity to do an act, when he very shortly after publication did the act, unsurprisingly they were allowed to rely on it. That's the Maisel-Godman line of cases. I agree with him. In order to make good a plea of fair comment, it must be a comment on facts existing at the time. No man can comment on facts which may happen in the future. Then there's a passage in Gatley which goes further. It says the facts which the defendant seeks to prove as the basis of the comment must have been known to him when he made the comment. And then Lord Denning greets that with a degree of caution. I do not know that I would go quite so far as that. And then he adds this slightly Delphic observation: a man may comment on existing facts without having them all at the forefront of his mind at the time. When we come to look at Mr. Justice Eadie's formulation, we get into depths of philosophy which really no jury, we respectfully say, could possibly make findings of fact about. Now, we then get to Lord Justice Davis, who cites the Scottish case. He deals with a note from Fraser, which again rather reflects what appears in the Folks Committee report. That note is supported by a reference to a Scottish case. The jury are entitled to know what was in the defender's mind at the time he made his comment. Otherwise, they'll not be. But pausing for a moment, perfectly proper for malice, of course, to know what's in his mind. That's where one suspects that the confusion has arisen.
Could I just put this to you? Your thesis is this is all about vindication.
Yes.
Is it not about two conflicting
Yes.
principles? One is vindication and one is freedom of speech.
Yes. Yes.
If you didn't have freedom of speech, there'd be quite a lot to be said for a claimant being entitled to relief if a comment was made which was biased, outrageous, unfair.
Yes.
But that's balanced by the importance of freedom of comment. But freedom to comment if you've got a basis for your comment. But freedom of speech needn't and perhaps shouldn't go so far as to entitle one to say, I've done nothing wrong, even though you've made an outrageous comment which had no basis at all, so far as you were concerned.
Lord, firstly, your Lordship is undoubtedly right that it is a balancing exercise. Mr. Justice Diplomacy, then, what is summing up in Slim, puts it exactly that way. Silkin and Beaverbrook, he later approves it in Slim. And he says, we do have to balance here reputation on the one hand and the right to free expression on the other. I didn't probably put it very well when your Lordship put the point to me earlier. That passage in Lord Ellenborough that I referred to earlier recognises that there will be some quite harsh cases, but if you accept a considerable social utility in free discussion on public interest issues where there is a factual basis within the objective test, if you accept that, the moment you start to stigmatise the person who gets his facts wrong, who doesn't know enough facts, we say that's unduly trespassing on the free expression side. And secondly this, a claimant can be taken to know, broadly speaking, what facts are out there. He can be taken to know what he's done and what he's said, and he can be taken broadly to know what official reports, there may be exceptions on exceptional facts, but generally speaking, a claimant knows what's out there. Unless he has reason to believe that he's dealing with a dishonest commentator, well, why isn't the law, broadly speaking, sufficiently met by it's only where the comment is truly invalidated by the absence of any proper facts that vindication should come? In a case where there's no defamatory statement of fact, the moment, I keep coming back to this point, the moment there's a defamatory statement of fact, and if I may, I'm going to trespass on this case once and once only, just to make this point. If I attribute to someone a statement that he says, I don't care at all about my contractual obligations, with a great respect, that's a defamatory statement of fact. You're attributing him a statement which you're attributing something he has said, that's a fact, which would make an ordinary person think the less of him. And I've no doubt that's why there's a plea of justification in this case, as well as a plea of fair comment. Also, in this piece, there are plainly some opinions. But one must always remember the importance of that safeguard, that where there are facts either in the piece or which the reasonable reader would infer from the piece, they have to be justified. I'm sure your Lordship is right that one can think up some harsh cases. Most obviously where the facts aren't defamatory, but they're colourable, or if that's some other word one can use, they do, as I think Mr. Bennett might say, give a bit of credibility to the defamatory comment, and they're wrong. I think that's the case where one has a degree of unease.
Yes. Now, justification of the facts, you say, is only where the facts themselves are defamatory.
As set out in the words complained of ought to be inferred.
Yes. Can you just help me with this example, which may not be very realistic? A says, you don't want to deal with this particular group because they have been advised by their lawyers that they don't have to have any regard to this particular clause. Would you have any remedy there as a member of the group if that was entirely untrue?
It has the ring of a malicious falsehood case to it rather than a libel case to it, assuming for the moment that they hadn't been.
Yes.
That would be the first point. If I may say so, it's a probing example because it's not defamatory of the claimants, it's defamatory of the lawyers.
Yes.
My feeling is that the best answer to that case is it's actually damnum sine injuria because it's not defamatory of the claimants, it is defamatory of the lawyers.
Yes,
if the lawyers hadn't advised, then they would have a claim in libel.
Yes, yes.
The trouble with this area of the law is an infinitely fertile source for examples which cause one's trouble. I mean, to be candid, one of the examples that always cause me difficulty is the very bland opinion. Caldecott is a disgrace to his profession. Now, the trouble with that is you simply are not told whether what's underlying it is something on which people could agree or disagree, namely he opens his cases too high or he's rude to witnesses, something on which people could disagree, or whether it means that he lies to the court. Now, it's in that very bare opinion that the authorities tend to say you're at real risk of that being found to be a statement of fact because you have not indicated the subject matter with sufficient precision. My Lord, if I could just venture a public interest which is served, which is different from Lord Nichols's public interest. Lord Nichols's public interest is that the reader can judge for himself whether he agrees or not. But we say there is a lower but much more realistic public interest, which is that if it's sufficiently identified, at least the reader, if he's interested, can investigate. And that may be an important and potent public interest. But as the cases say, dividing statements of fact from opinion can often be difficult. And when your Lordship mentioned artistic criticism, one's instinct as to why that's different is because it's so much easier.
Yeah.
Because the substratum is absolutely obvious. It's also nearly always the kind of opinion that cannot be justified. Can occasionally, that a book is obscene, it can be justified occasionally, but that it's bad or I didn't enjoy it or whatever, that's all pure value judgment. Well, I'm not going to go to it, but I do think it is the point the Lordship made about balance. It is important to understand there is a sort of fashionable view that this is all post-Human Rights Act, this question of balancing reputation against freedom of expression. It isn't at all. If one looks at Justice Diplock summing up in Silkin. It's classic balancing of reputation against freedom of expression. It's been in the common law right the way along. It's just that it's been found to be particularly difficult in this context of opinion. So I'm not proposing to go to Article 8, Article 10 controversies. Now, my Lord, just to complicate matters, there is a very curious passage in Lowe where Section 6 was not relied on for the simple reason that almost all the facts were extrinsic to the article. Almost none of the facts were set out or referred to apart from the reverse takeover. It's at tab 23. Ironically, this is slightly going back to the section 36 conundrum, as Mr. Justice Eadie points out the problem without having forgotten, because it wasn't cited, that section 6 actually answers it. It's tab 23, paragraph 35. He's just set out Lord Porter's distinction between only having to prove one of the 20 if it's outside the article, but having to prove all if it's inside the article. Then he says this at paragraph 35, having we respectfully say forgotten section 6, whether such a stark distinction would be drawn today between facts stated and pleaded is open to question. I should be surprised if it were now to be held that the omission to establish one important fact would lead to overall failure, merely because it had been stated in the article. That would appear to be inconsistent with the policy underlying the rule with regard to justification, that the word complained of need only be shown to be substantially accurate. I can see no principal distinction in this regard between two defences. Moreover, I should be surprised if the proposition were to be found compatible with Article 10 in the Strasbourg jurisprudence, which generally allows leeway for journalists in the exercise of their trade so as to accommodate a degree of inaccuracy and exaggeration. So rather ironically, in fact, Parliament had addressed precisely this problem in section 6. And what I haven't touched on is really what to my clients is obviously a major objection to the knowledge setting out the facts problem, which is the position of reporting the opinions of third parties. I haven't touched on that at all. Your Lordship will remember that in Lowe, Mr. Justice Eadie has a detailed formulation of what knowledge means. In relation to those who purvey third-party opinions, which the media do all the time, he says we don't have to know the facts, we merely have to prove that the commentator knew the facts. But that poses, when you start to think about it, all manner of problems. First of all, pre-publication. I mean, one knows oneself that the letters editor has his letters, he goes through them at 5 o'clock and he decides what to put in. He hasn't got time to conduct a full inquisition. He will have a broad idea as to what is out there, and if he gets it wrong, of course, he won't have enough facts to support it and he'll be vulnerable. The idea that he has to be satisfied that the original commentator knows the facts is enormously burdensome. And then, of course, there's the problem post-publication. Quite often, commentators who contribute run a mile the moment they smell litigation and they've not been sued because they haven't got the money and the media entity has been. The last thing they want to be is dragged in and you can't get any information. Mr. Justice Eadie is right. You have to sign a statement of truth confirming that the commentator knew the facts, but it is, with respect, completely impractical. And there is also the case of Lyons in the Daily Telegraph, the fictitious letter writer, your lordships may remember, which is really direct authority, that it would be completely an undue burden for the media to have to investigate the background knowledge reality in that case, where the writer was fictitious. Lord, I'm conscious I'm limited to an hour, and I think I've really have covered almost everything. Lord, could I just say this? There are a number of other controversies I have touched on in our written case, and I fully accept that it's not proportionate or sensible to deal with them all. But having urged that this defence does require looking at in the round, I would just ask your lordship to bear in mind some of the wider points we make. We by no means are asking for a carte blanche. We accept public interest. we accept the malice honesty curb, but we do say that knowledge and referring to the facts is going too far and an undue intrusion on the practicalities of journalism. Can I also just thank your Lordships for giving us permission to intervene? It's much appreciated.
We're very grateful for your assistance. 11 o'clock tomorrow.